of this month, my lord.
What is that matter?
That is
What is the matter?
BLAPL.
Give it,
I'm permitted to make mention, my lord, one tied up matter for bail, my lord.
please.
Well, in this case, some of the co-accusers are already resident,
Give it.
my lord. And another matter, one criminal appeal for bail.
Tied up bail.
Tie up
Criminal
bail
appeal.
more than 5 years in custody and petitioner is ready, your lordship. Please.
Criminal appeal 7 years in custody.
Give it.
My lord, criminal appeal relating to PC Act, my lord. Paper book is ready, my lord.
Hearing.
Hearing, my lord.
Oh, mention next week. Okay.
RPFM tied up your pass an order. Now it is in the stage of final hearing. That interim order should not be
RPFM, is it been assigned to me?
long.
Huh?
No, my lord, yeah.
RPFM, I'm it has
My lord,
not.
your lordship pass an order on 11/10/2017. Now it is for final hearing. I have
No,
final
why are you mentioning when the matter is not assigned to me, as was told? It is RPFM is not assigned to me.
Yes, my lord. Previously, it was disposed of by your lordship, my lord. I have
So
filed
you
an
have filed
interim.
an interim application. All right.
Tied up.
Lordship appeal against conviction, your lordship.
You will be tied up.
Matter related to interim bail, my lord. Matter was adjourned specifically, but it could not
Give
be
it.
tomorrow, my lord.
Give it.
Millards, I am mentioning from the list, Millards, today's list. Item number 12 on behalf of Mr. Bigyan Kumar Sharma, I am seeking for a short adjournment.
Please wait, and when the matter reaches, make a mention.
Okay.
Yes.
Yes, Millards.
Weekly list item number 1.
May I please, your lordship? Conviction under section 376, my lord. 372 2N, my lord, and under 6 POCSO Act, along with 363 and 366, my lord. Punishment for 20 years, my lord. 20 years along with others, my lord.
Admit
supplied the
for
copy.
the trial court record.
I've supplied the copy of the depositions, my lord.
You have already supplied.
Now,
Item 2.
May I please, Your Lord? My lord, 20B2C, my lord, 14 years conviction, my lord. And fine amount to rupees 1 lakh.
Admit same order.
Oblige yours.
Item 3.
Yeah,
Mr. Roy.
it's a vigilance case, my lord. 1 year conviction. It is a running page 111.
No, there is 2 years is there. Why are you saying 1 year?
My lord, arrive for 1 year, pay fine 10,000.
Yes.
Difficult to undergo for the period of arrive for 3 months. Under section 465, 34 of IPC.
Yes.
Then arrive for 1 year and to pay a fine of 10,000 in default to undergo arrive period of RI for 3 months. Under section 471, 34.
Yes.
RI for yes, sorry,
So,
RI for 2 years.
so the maximum sentence is 2
2
years,
years,
not
yes.
1 year. And you are on bail during trial.
Yes,
But you are not arrested. How will were released on bail?
my lord, I was
See
on statute.
page number 2.
Page number?
Page number 2. See the date of arrest. Date of arrest hyphen date of release on hyphen.
My lord.
You are not arrested in
No,
doing investigation. Make the proper submission where yes, Mr. Das.
yes, my lord, I have received the copy. I will file my appearance memo by the end of June.
Admit he was not arrested during investigation. Bail granted. Stay realization of fine. Free copy of the order be handed over. He will file the appearance You were on bail during the matters. Admit. Counsel engaged. Intimation is to be given. Call for the trial court record.
Appeal
Yes.
memo.
Appeal memo to be furnished to the learned counsel for the state. Yes.
Item 9.
Mr. Tupuna Kumar Mishra. Is a CST matter? Or?
My lord.
Somebody has entered appearance. Manonjan Acharya not there. You have received the case diary?
My lord.
2021, why it is pending now? Rejection order is dated 9/7/21. Take down. None appears for the petitioner, so also for the informant. An application for bail. The rejection order is dated 9/7/2021. If the case is still sub judice in the trial court, the appellant is at liberty to renew the prayer for bail in the trial court, disposed of.
Item 10.
Yes, Mr. Malik, and who is for the informant?
This is the
So,
appeal.
You have received the case diary?
No, I have not received the case diary.
So,
Is it against acquittal, my lord?
oh, it's acquittal.
My lord.
Okay. What is the offense? 391, 341, 294,
506.
506.
Read with 31R, 31R,
For
SC2VA, assistant.
what is the date of occurrence?
My lord.
Date of April, my lord.
25/8/2016.
So, is 341, 294, 506 acquittal order has been passed by this court will entertain such an appeal.
My lord, condone the delay, my lord.
It's all right. I have condoned the delay, but on merit, in a 341, 506, 294 matter, why acquittal order will be interfere, and if I admit this appeal, it will go to how many years? Do you know that?
The other allegations, my lord, these are 3 SCHR. That is a clear
It's
made
all
out.
right, 3 years CSTR.
My lord, kindly peruse the order, the judgment of
What is the perversity in the judgment? You know about the scope of interference in the appeal against order of acquittal. So a detailed judgment after analyzing the evidence of each of the witnesses has been passed. So what is so glaring infirmity or perversity so that I will interfere in a 341, 294 case, 506 case?
Kindly peruse the witness of 8, my lord.
Hmm?
Evidence of PW8, my lord.
Yeah.
I am reading it, my lord.
The finding is that page number, running page 19, internal page 11, the evidence of the PW8 was recorded after the evidence of the IO, and his evidence is no way helpful to the prosecution as it goes inconsistent and contradictory to the statement of victim itself.
My
So,
this is the analysis of the London Lower Court, my lord. My lord, he is an purely independent witness. He is a service. And
all right. Heard the learned counsel for the appellant, learned counsel for the respondents number 2 and 3, also the learned counsel for the state. This criminal appeal has been filed by the informant. This man is the informant.
my lord.
Informant Bichitrananda Sethi, challenging the judgment and order dated 18/7/2022, passed by the learned presiding officer, Special Court under SC/ST POA Act, Cuttack, in city case number 110 of 2016. In acquitting the respondent number 2 and 3, the offences punishable under section 341, 294, 506 Part 2 by 34 of the Indian Penal Code, read with section 31R S oblique 32 VA of the Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act. The prosecution case in short is that quote from paragraph number 2. In order to prove its case, the prosecution examined so and so witnesses, 8 witnesses, and exhibited 3 documents. The Learning Trial Court, after analyzing the evidence of PW1, the informant, who is the only injured in this case, has been pleased to hold that the ocular testimony of PWs 2 to 3, 2, 3, 4, and 5, who are the co-villagers of PW1, are quite contradictory to each other, and there are significant differences and variations, and therefore their evidence cannot be safely utilized. It was further held that PW1 was in a habit of filing false SCST case against others, and there was enmity between him and the respondents number 2 and 3 due to civil litigation, and therefore it would be unsafe to rely upon his evidence, and as such his evidence also his evidence also suffers from embellishments and developments. The Learning Counsel for the appellant submitted that the evidence of PW8 has not been properly taken into account by the Learning Trial Court. However, I find that the Learning Trial Court has dealt with the evidence of PW8 in paragraph number 6.5 of the impugned judgment, and has been held and which pleased to her that the evidence of PW8 was recorded after the evidence of the IO, and his evidence is no way helpful for the prosecution, as it goes inconsistent and contrary to the statement of the victim, bracketed PW1 himself. As the evidence of PW8 varies from the basic story, his evidence cannot be applied for corroboration and therefore wholly unreliable. Accordingly, the Learning Trial Court came to the conclusion that the prosecution has failed to prove the case against the respondents number 2 and 3 beyond reasonable doubt. Accordingly, acquitted the respondent number 2 and 3 of all the charges. Law is well settled if that principle of so and so. After going through the impugned judgment, the analysis made by the Learned Trial Court, the evidence of the witnesses, and after hearing the Learned Counsel for the parties, I find that there is no perversity, illegality in the impugned judgment, so as to interfere with them. Accordingly, the CRL being devoid of merit stands dismissed. Yes, next.
Item 11.
And you have received the case diary?
No.
Okay, CD and criminal antecedent.
Social investigation.
Social investigation be obtained in the meantime.
Item 12.
Yes, Mr. Sharma.
12, I was seeking for an adjournment.
Okay. These are all orders matter, madam. So when your senior has asked to take adjournment, don't make mention at the first hour. You have to keep patience and learn to how to keep patience. After mentioning, you will go somehow or other to other courts, or that is not proper. Okay.
Yes, my lords. Next time I'll.
If you have no time, you should ask your senior, sir, I have no time.
No, my lords. Next time I'll
All right.
keep in.
Yes. 6 for an adjournment. Yes. Next.
Item 13.
My lords, interim order is there in this case.
What is this matter then?
Interim order dated 19, in order dated 19/2/2024.
What is this CRLA for?
This CRLA is, my lord, in
Challenge the cognizance.
cognizance. The petitioner, my lords, is the principal of an institution. The colleagues instituted a case in which the final form has been filed, stating that no case has been made out. After that, my lords, the informants, they have given that under compulsion, they have given the statements.
So the proceeding has been stayed as per order dated 19/2/2024.
Yes, my lords.
And if you are seeking for adjournment, I will vacate the order of stay and ask the trial court to proceed.
Then, my lords, I'll seek for a short adjournment next week.
Court of this matter next week. Interim order dated so and so. Extended till next week. Hello? Yes.
Okay.
Give a date, no, till next date. Yes. Yes.
Item 13.
13 by play management method to be taken up next week. In the meantime, I will
my lord, ये जो ओडिया अनेस्वर undertaking.
Okay, leave it.
Last
And
my lord,
there
call
was
for
a
status
delay of
report.
39 days that has been
My lord,
found
hold on.
found on. You have received the case diary?
No, my lord.
The crime branch case, my lord, last
Crime
one.
branch is hand over to crime branch. Let it be.
And what are the offenses?
My lord, offense, my lord, of
307 for
30
and
302, my lord. 294,
accountable.
452, 354, 302, 506, 34.
307 has turned to 302
My
case.
lord.
Okay. So you get
My lord,
the,
petition is juvenile, my lord. In custody already, my lord, 13/1/2017.
it's already he is not having the case, right?
Last occasion, my lord, call for status report, my lord.
Status report has come and
Till date, trial has not started.
just a minute. Yes, it is mentioned that charge sheet has been submitted under 302 and other offenses. And cognizance has been taken and then it was transferred to the additional session judge cum special judge Bhavani Patana, where charge has been framed. And trial has also commenced, and out of 45 charge sheet witnesses, 18 witnesses have been examined. So, where is the deposition copy of those witnesses? When you are getting a brief
Sure.
and arguing a matter after a year or 6 months, you are expected to take instruction that what is the status of the case. And if witnesses have been examined, you are to get the certified copy of the
Okay.
deposition.
Okay.
Peruse the status report furnished by the London Trial Court, from which it revealed that out of 45 charge sheet witnesses, 18 witnesses have already been examined. London counsel for the petitioner seeks some time to obtain the certified copy of the deposition of such witnesses and file the same and giving copy thereof to the London counsel for the state, who also seeks time to produce the case diary and criminal antecedent, social investigation report. In the meantime, put up this matter. Kete samay darkar apanku?
2 weeks time.
So let it come on 15th.
My lord.
Okay, put up this matter.
15 night 22 asu.
Acha, 22nd of April 2024.
Okay.
Free copy of the order be handed over. Yes.
Item 16.
Item 16 can taken up next week, madam.
And Mr. Das, you have received the case diary and
No, my lord, I have not received.
so
Social investigation received. City not received.
कौन सा receive करजन?
Social investigation.
अच्छा. London counsel for the petitioner seeks for an adjournment. London counsel for the state submits that he has received the social investigation report, but seeks some time to produce the case diary. Among केबे दरकार?
Next week, madam.
Next week न हबानी 8 तारीख पर्यंत 8th of April 2024. CDB obtained in the meantime. Yeah.
Okay.
Item 17. Item 21.
May I please, my lord? My lord, this is a this appeal is for bail application under the CST Act. Notices are required
Notice to be go.
Hmm.
Notice to be go.
SC/ST matter.
Yes, ma'am.
Yes, my lord.
First time was you.
Yes.
Yes, my lord.
Right. Extra copy. Notice. CD. CA. 8/4/2024. Yes, next.
Oblige, my lord.
Item 22.
May I please, your lords? Petitioner.
File the FIR copy, my lord.
Notice दरकार की किसी 20B2C9.
20B2.
All right. So give the copy of the FIR to the Land and Council. FIR copy to be handed over to the Land Council. Yes.
Item 23.
23 Millers, I beg a pardon to appear through VC Millers.
Yes, sir.
I have personal difficulty.
Yes, yes.
It's directed state to obtain instruction with regard to whether the petitioner has misutilized the liberty granted during interim bail, Millers. Last occasion, Lordship directed.
Just a minute. Let me see that order. You made a submission on the other day that
Lordship.
twice you have been granted interim bail
Interim bail, yes.
and you surrendered at right time.
Right, Millers.
So that was your submission. That is how I asked the State Council
Lordship.
to obtain instruction whether you have misutilized the liberty or not.
Alright.
So what is your instruction, Mr.
Instruction is that both are not well reputed in the locality. Their activities are suspicious in nature.
No, that is not
That is
that is not the answer. That is the what was sought for, whether suppose any case or any
Yes,
kind of utilization, and he was forwarded to court on 29/2020,
22. Lordship.
and as it appears, last time he was granted bail, interim bail,
Lordship.
on
18/5/2023,
5/23, right?
Millers.
And he surrendered after availing the interim bail period on 21/8/23.
Lordship.
So except that there is no other material that he has misutilized liberty, or the Learned Counsel for the petitioner, Learned Counsel for the state. Learned Counsel for the state up for the order dated 14/3/2024 has obtained instruction that though there is nothing in the report of the kaha report the
IIC
IIC
Sadar PS Khurda.
Khurda Sadar Police Station that the petitioner has misutilized his liberty while on interim bail in any manner. However, it is mentioned that the petitioner's conduct is suspicious. Suspicious. Peruse the status report submitted by the Learned Trial Court, from which it reveals that out of 18 charge sheet witnesses, 5 witnesses have been examined, and twice the petitioner has been granted interim bail, and on each occasion after availing the same, he surrendered at right time. Considering the submission made by the Learned Counsel for the respective parties, Mr. Subhas Mansingh, Learned Counsel, appearing through virtual mode. Learned Counsel for the state, for hearing the Learned Counsel for both the parties. The period of detention of the petitioner in judicial custody. Absence of any material that he has misutilized the liberty while on interim bail. and also going through the report furnished by the learned counsel for this. That would copy would they we inclined to release the petitioner on interim bail for a period of 3 months disposed of. Yes.
Urgent certified copy.
Yes. Copy that. Yes.
Item 24.
May I please, your lordship. Last occasion on 14/3/2024, my lord directed to my lord and senior state counsel obtained instruction regarding my lord misutilization of interim bail. Whether as because my lord the petitioner custody since 1960.
Yes, Mr. Tripathi.
That has not instruction has not
Ah,
instruction has not come.
14 order itla.
Yes.
Twice he has been granted interim bail,
Yes.
and his submission is that after availing the same, he surrendered at right time and not misutilize the liberty in any manner.
A letter has also not sent.
So get it next
Yes.
week. We'll take up. Learned counsel for the state seeks some more time to obtain instruction as per the order dated 14/3/2024. So whether it will be on 2nd or 8th as you want.
8th.
8th. All right.
Okay.
8th April 2024.
Item 25.
My lord, in this case, last occasion, your lordship directed to take the instruction. They were trial, my lord.
Mhm. You made a submission that out of 66 witnesses, 24 have been examined. Last witness was examined, that is PW 24, on 31/7/23, and no further witness has been examined. That is how the report was called for. What is the report now? Status report. Okay, status report indicates that 32 witnesses have been examined. So out of 66, 32 examined and 20 declined. So he has also sent the deposition copies.
Lordship, kindly solve to me, my lord. Copy.
27, 28, 29, 30, 31, 32. You are having the deposition copy up to PW 24.
23.
23.
23, 24, my lord.
24, right.
24, my lord.
So, Mr.
Yes.
Tripathi, Mr. Tripathi,
Yes, my lord.
ଆପଣଙ୍କ ପାଖରେ deposition copy ଅଛି?
Sir, good.
ସେ କ'ଣ ଦେଇଥିଲେ ଆପଣଙ୍କୁ?
Yes.
ଦେଖନ୍ତୁ। କେତେ ଯାଏଁ ଅଛି?
23.
24ଟା ହେଇଥିଲା କ'ଣ କହୁଛନ୍ତି?
Yes, sorry, my 24.
24 ବାକି ସେ learned trial court ପଠେଇଛନ୍ତି up to PW 25 to PW 32 ପର୍ଯ୍ୟନ୍ତ. I'm directing the registry to hand over set of deposition to you as well as to the counsel for the petitioner. We'll take up this matter next week. Peruse the status report furnished by the learned trial court, which indicates that out of 66 charge sheet witnesses, 32 witnesses have been examined, 20 witnesses have been declined. The learned trial court has sent the Xerox copies of the deposition of PWs 25 to 32 as per the order of this court. Let the registry supply a set of deposition of PWs 25 to 32 to the learned counsel for the state as well as to the learned counsel for the petitioner put up this matter in the week commencing from 8th April 2024. Yes. You go and receive it, Mr. Mrs.
Item 26.
May I please, Your Lordship? Your Lordship, I may be pardoned to appear virtually, Your Lordship.
What do you want?
Your Lordship, while order dated 2012-2023, you have directed this present petitioner to surrender, Your Lordship.
Okay, 4 weeks time was granted to you.
Yes, Your Lordship, but Lordship, due to some miscommunication, the conducting counsel could not
Okay, now you want
communicate.
extension.
Yes, Your
What
Lordship. Just
period
2
you want?
weeks.
2 weeks time.
2
All right.
weeks, Your Lordship.
So surrender by honor before 15th of April 24.
Obliged, Your Lordship.
IA number swan. So it is extended till 15th April 2024. IA disposed of.
Item 27.
Mr. Panda.
Yes, my lord, the earlier order may be. Order number 5. He has not served a copy.
All right, peruse the the report of the learned session judge Tenkana dated 21/3/2024, from which it appears that the appellant was admitted to district jail Tenkana on 19/12/2018, and he remained as UTP, and after his conviction on 15/9/2010, he remained there till the expiry of his sentence, that is 25/5/2020, and was released on the same day after remission of 743 days under the remission rules. The appellant has sent a petition which is at flag B, wherein he has mentioned that he did not want to engage any counsel and wants to undergo sentence imposed by the trial court. Since the appellant has already undergone the sentence imposed by the trial court and not interested to proceed with the criminal appeal, and he has also been released from judicial custody, the criminal appeal is disposed of. Yes, next.
Item 28.
May I please? Appellant in custody mail 6/9/13, my lord.
and the fixed dates we will file the surrender certificate.
Item 31.
May please, Lordship, my lord, has directed the government to verify the documents submitted by bail number 2.
Learned Counsel for the state has obtained instruction that the address furnished by the appellant number 1 in the cost title is correct. While the document which is taken, however, she submit that after receiving the documents of the sureties, the surety verification has been sought for, but instruction in that respect is awaited. And say to is surety verification by document ଦେଇଥିଲେ
ନାଁଟା କ'ଣ ସେକେଣ୍ଡ ର?
ଦି ଜଣଙ୍କ ନାଁ ଦେଇଥିଲେ ଆପଣ
ଅଭିମନ୍ୟୁ ଗୌଡ଼।
ଆଁ
ଅଭିମନ୍ୟୁ ଗୌଡ଼ ସାର୍।
ଅଭିମନ୍ୟୁ ଗୌଡ଼ ଆଉ ଗୋଟେ ଆଉ ଜଣ ନା
ସେଇଟା ସାର୍ ହେଇଯାଇଛି ସାର୍ ଆଗରୁ ସେଟା ଭେରିଫାଇ କରେକ୍ଟ ସରିଯାଇଛି।
ଜଷ୍ଟ ଏ ମିନିଟ୍ କାହାର ଠିକ ଥିଲା ବୋଲି ଆପଣ ଆଗରୁ କହୁଥିଲେ ଜଣଙ୍କର ଭୁଲ ଥିଲା ନା
ବଳରାମ ସାହୁର ଠିକ ଥିଲା ଆଉ ଲୋକନାଥ ପ୍ରଧାନର ଠିକ ନଥିଲା। ବଳରାମ ସାହୁଙ୍କର ଠିକ ଥିଲା, ଲୋକନାଥ ପ୍ରଧାନର ଠିକ ସେ ରହୁନାହିଁ ସେଠି ବୋଲି
ବଳରାମ ସାହୁ ଠିକ ଅଛି। ବଳରାମ ସାହୁର ଭେରିଫାଇ ହେଇଯାଇଛି ସେଟା ଜେନୁଇନ୍ ଅଛି, ଡକୁମେଣ୍ଟସ ଆର୍ ଓକେ। ସେଇ ଯୋଉ ଅଭିମନ୍ୟୁ ଗୌଡ଼ ପାଇଁ କୁହାଯାଇଥିଲା ଭେରିଫାଇ କରିବାକୁ, କଣ ଆସିଲା ରିପୋର୍ଟ?
Yes. The IAC sought for verification from the Tahsildar, but no received any reply from him till today.
କେବେ
ଏଇଟା ହଉଛି 29/1/24। ତାପରେ ନାଇଁ 29/1/24 ତାପରେ ପଠେଇ ନାହାନ୍ତି କହୁଛି।
ପଠେଇ ନାହାନ୍ତି କଣ କରାଯିବ ବର୍ତ୍ତମାନ ଆପଣଙ୍କର ଆରଓଆର ଟା ସିଏ ଆପଣଙ୍କୁ ଦେଲେ, ଆରଓଆର ଟା ଆଜିକାଲି ସବୁ କମ୍ପ୍ୟୁଟରାଇଜ ହେଇଗଲାଣି, ସାଙ୍ଗେ ସାଙ୍ଗେ ତାକୁ ଗୋଟେ ଭେରିଫାଇ କରିବାକୁ ଆପଣ 2 ମାସ ସମୟ ନେଲେଣି। ତହସିଲଦାର ଏତିକି ଆରଓଆର ଟା ଜେନୁଇନ କି ନାହିଁ, ସେ ଲୋକଟା ନାଁରେ ଅଛି କି ନାହିଁ, ଏତିକି ଭେରିଫାଇ କରିବାକୁ 2 ମାସ ସମୟ ଲାଗିଯାଉଛି। ଘରେ ବସିକି ଲୋକ ଜାଣି ନଉଛନ୍ତି ଠିକ ଅଛି ନା ନାହିଁ। ତ ଜଣେ ବଳରାମ ସାହୁ ନବ ଆଉ ଅଭିମନ୍ୟୁ ସାହୁ ଗୌଡ଼ ନବ, ତାକୁ କୋଉଠିକା ଲୋକ ଇଏ?
ଅଭିମନ୍ୟୁ ଗୌଡ଼ ହଉଛି ପୁରୁଷୋତ୍ତମପୁର ଗଞ୍ଜାମ।
ଆଉ ଇଏ ଏଇଟା ହଉଛି କାହାର ଆପେଲାଣ୍ଟ ନମ୍ବର 1 ର ନା କାହା ପାଇଁ ବେଲ୍ ଆପ୍ଲାଏ କରିଛନ୍ତି? ଆପେଲାଣ୍ଟ ନମ୍ବର 1 ନନ୍ଦରାମ। କେତେ ଦିନ ରହିଛି ସେ?
8 ବର୍ଷ ମାସେ ହେଇଗଲାଣି।
କେତେରୁ?
31/1/16।
ସେଣ୍ଟେନ୍ସ କେତେ ମ?
15 ବର୍ଷ 32B ରେ ସେ ରିଲିଫ କ୍ଲେମ୍
32B କନସିଡର କରିନାହାନ୍ତି
ନା, ହେଲେ ବି 8 ବର୍ଷ ମାସେ ହେଇଗଲାଣି।
Heard the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submitted that while convicting the appellant number 1, Nandaram alias Karan, under section 20B2C of the NDPS Act, and imposing sentence of RI for 15 years and fine of rupees 1,50,000 with default sentence, the Learned Trial Court has not taken into account the provisions under section 32B of the NDPS Act. He further submits that the petitioner was taken into judicial custody on Kebe
31st January 2016.
31st January 2016, and as such he has completed more than 8 years of substantive sentence. He further submits that paper book has not been prepared and therefore there is no chance of early hearing of the appeal, and balance of convenience is in his favor. And therefore the bail application may be favorably considered. Learned counsel for the state has already obtained instruction that the address furnished by the appellant number 1 in the cause title is a genuine address. Similarly, the documents up to local sureties were furnished to the learned counsel for the state, and so far as local surety Balram Sahu is concerned, the learned counsel for the state submitted that is a genuine bailer and the documents are authentic. But so far as local surety Abhimanyu Gowda is concerned, even though adjournment has been sought for by the learned counsel for the state on number of occasions to verify his documents, however, today the learned counsel made a submission that though the IIC sought for instruction from the concerned Tahsildar for verification of the documents in respect of local surety Abhimanyu Gowda in January 2024, but the instruction is still awaited. Since the case has suffered a number of adjournments for this purpose, taking into account the period of detention of the petitioner in judicial custody and the ratio laid down by the Honorable Supreme Court in case of Muhammad Muslim versus State of so-and-so, I am inclined to release the petitioner on bail subject to condition that Balram Sahu and Abhimanyu Gowda shall be the two local sureties for the appellant number 1, Nandaram alias Karan. Allowed.
Obliged.
Item 32.
Wait, please, madam.
Yeah.
It's herein, the petitioner has been sentenced and convicted.
Item 34.
May I please, Your Lordship?
A date
Your
fixed
Lordship,
for
kindly,
surrender certificate.
Your Lordship, kindly have a glance on the last order, Your Lordship. In that, the state was directed to obtain the status that when the petitioner was on bail, whether he committed any such criminal activity or not.
That is order dated 11/3/24. And you made a submission that thrice you have been
Yes, Your
granted interim bail, and on each occasion after availing the same, you surrendered at right time.
Yes, Your Lordship.
And State Council was supposed to obtain instruction from Inspector of Excise, striking force Chhatrapur Ganjam, as to whether so and so. Acha, ଆଉ ଗୋଟେ report ମଧ୍ୟ call for ହେଇଥିଲା.
Your Lordship, please.
Report ରେ ଆସିଲା କଣ ଆଗେ ଦେଖିଦବା. In obedience to surrender before the after expiry of the acha ଠିକ ଅଛି. Yes. Report ଦେଖୁଛି ଠିକ. ଆପଣଙ୍କର କୁହନ୍ତୁ.
Let it come next week.
ଆପଣ ଖାଲି instruction ହଉଛି misutilization of liberty.
Yes.
That is to come from the Inspector of Excise. So get it next week, huh? All right. Period the report of the Lennon trial court from which it reveals that after expiry of the interim bail period on each occasion, the petitioner has surrendered at right time. Stop. The London Council for the State, however, seeks some time to obtain instruction from the Inspector of Excise Striking Force Chhatrapur Ganjam as to whether the petitioner has misutilized his liberty in any manner or not during the period of interim bail. Put up this matter in the week commencing from 2nd April 2024. Yes. Rongo jor khelo hoichi bodhe kali. Yes. Next.
Item 35.
May I please? Will kindly have glance to earlier order. As for your lordship direction, I have already filed the surrender certificate.
Surrender certificate कौन हल्ला?
I have already filed the surrender certificate.
Not filed election केबे file कले? Registry note देइची surrender certificate अच्छा अच्छा flag aim दिया है. Okay, all right. So again you have filed this surrender certificate is for appellant number 1.
Appellant number 1.
Now you have filed the IA for appellant number 2.
2, my lord.
So what period he has remained in custody?
As for I have obtained the custody certificate. As for the custody certificate, he is in custody, my lord. 5 years, 4 months, 16 days.
Sentence कितने है जी?
Sentence, my lord, 10 years.
देखिए, लोगों को दिया रहा.
Belongs to Jaspur, my lord. And your lordship was on 2 occasions. Your lordship was granted bail, and in time he also surrendered.
Yes, 5 वर्ष 4 मास को देंगे certificate. Out the London Council. This is IA number 3045 of 23. This is an application for bail of appellant number 2. The name is Surendra Sahu. Land Council for the petitioner submits that the petitioner was granted interim bail twice.
Yes,
and after availing the same, he surrendered at right time. And out of what is the sentence imposed?
10 years.
10 years.
Out of 10 years of substantive sentence imposed by the trial court, he has already undergone more than 5 years of sentence. In support of such contention, he has produced the custody certificate dated, issued by Superintendent Model Convict Prison Artgod, dated 21/3/2024, which is taken on record. Considering the submission, sentence imposed by the trial court, period already undergone by the so-and-so, conduct of the petitioner in complying the earlier orders of interim bail, and further taking into account there is absence of any chance of early hearing of the criminal appeal as no paper book has been prepared, and also the ratio laid down in the case of Mohammed Muslim, I'm inclined to release the appellant number 2 on bail allowed.
Item 36.
Mr. Sahu?
Yes, Your Lordship.
Yes.
Convicted under section 20B2C of the NDPS
Sentence
and
kete?
10 years, Your Lordship.
Kete helani?
My Lord, after deducting the interim bail period, 8 years, 7 months.
Kahin custody certificate kahin?
Certificate nahi.
Oy moga hi thila na
Na,
first time.
moga hi nahi.
Mogi jo to. You were granted also interim bail.
Twice, Your Lordship.
So you surrender at right time.
Yes, Your Lordship.
All right. So learned counsel for the petitioner submits that out of 10 years of substantive sentence, he has already undergone 8 years of sentence, and twice he was granted interim bail, and after availing the same, he surrendered at right time. Learned counsel for the state shall obtain instruction through the inspector in charge of both police station as to whether the petitioner, there is any accusation against the petitioner to have misutilized his liberty while on interim bail or not. And also to produce the custody certificate. The report we called for from the plan and trial court as to whether the petitioner has surrendered at right time after availing the interim bail period or not. File be placed before registered judicial. So and so matter be placed on 8th of April 2024. Yes.
My Lord, Bausuni police station.
Huh?
Bausuni police station.
Just a minute. Get number item 36 देखिए 36 रो judgment of आया both police station लिखा है जी case था come to the judgment.
My Lord,
both PS case number.
Ishwar Patra, Your Lordship.
No, not a which police station you belong to, that's not material. The case is of both police station, right? You come to the judgment. In the judgment, after
Yes,
the
Your Lordship.
case number, it is mentioned. All right. Yes, next.
Which jail?
Both
jail?
jail ta kaun tha kaun?
Both jail.
Both jail.
Item 37.
Mr. Mishra, 2021 criminal appeal kaun eta?
My Lord, 1 week time may be given to remove the defect.
In the Bhinama.
Item 38.
Item 38, my lord, I'm on virtual mode, my lord.
Yeah.
And here your lordship directed the state council to obtain instruction with regard to the certificate of the mother-in-law of the petitioner furnished under annexure P by 2, page 12.
Yes, count.
Yes, madam. Instruction.
Contact Unadi. His mother-in-law has some ailment and he has applied for interim bail and
The mother-in-law of the petitioner, Tanu Maji, is suffering from complaint of pain in her chest and also dealing with slaughter speech. The medical document attached to the IA petition genuine. There is no male member present to look after Tanu Maji and her village, Angya Prasad, district Ganjam.
give that.
Yes.
IA number so and so. This is an application for interim bail on the ground of ailment of the mother-in-law of the petitioner. The learned counsel for the state was asked to obtain instruction on the interim application. Today he has furnished the written instruction received from so and so, which reveals as follows. Interim bail granted. You are granted interim bail for 1 month, surrender at rate. Yes.
Fine.
Item 39.
Surrender certificate file.
May I please?
Yes, Mr.
That I am appearing for the prison petition, my lord.
Huh?
No, I am appearing by prison petition, my lord.
The
petition is convicted for 10 years for the offense under section
you
370.
have filed your VNAMA.
Yes, my lord.
Prisoner's petition at flag A for engagement of advocate Devaki Marandi. In the meantime, Siddharth Mishra and Devaki Marandi filed VNAMA. Then another prisoner's petition received at flag B for engagement of advocate Lalit Kumar Bhuiya. So, Lalit Bhuiya ro eta latest rohuchi.
Yes, my lord.
You are Lalit Bhuiya. So you have filed your VNAMA, right?
Yes, my lord.
Okay. କାହିଁ ସେଟା ଦେଖେଇଲେ ଯୋଉଟା flag B ରେ ଯୋଉଟା ଅଛି Peruse the prisoner's petition dated it is 17 बोधे हाँ 17/7/2023 in which the appellant has requested for engagement of advocate Lalit Kumar Bhuiya as his counsel. Mr. Bhuiya has already filed VNAMA. The name of the other counsel except Lalitendu Bhuiya and his associate shall not be reflected in the cause list henceforth. Stop. So what is this application for bail?
The petitioner has been convicted for 10 years for the offense under section 370.
Where is the judgment? Judgment for the data. So sentence is for 10 years and 5,000.
Yes, madam.
But the offense is 376 2N.
2N.
And you are on bail during trial or in
No,
custody? Huh?
During trial, I am not in bail. From the date
So
of
what period you have already remained in custody?
about 5 years. 5
Is
years.
it trial court or yeta de?
Trial
court record ଟା ବାହାର କର ଟି trial court record.
31/5 5 ବର୍ଷ ହବ 5 ବର୍ଷ ହେଇନି
Record ହେଲା trial court record को କେମିତି ବାହାରିବ? ସେଠି କଣ ଖୋଜୁଛ? Go to the list. There is a TCR. So your custody is from 31/5/2019. Then whether you are gone on bail, no, not produced, not produced. Accused produced in custody, produced in custody. Okay. So out of 10 years you have remained in custody, it is
4 years.
4 years and 10 months ago.
Yes,
Right? Back kariye criminal appeal. Aguru kichi reject ହେଇଥିଲା କି bail application?
No, my lord.
No. Or the learned counsel for the petitioner, learned counsel for the state. The petitioner is in judicial custody since 31/5/2019. And as such, he has undergone almost 4 years and 10 months of sentence out of 10 years of sentence imposed by learned trial court. And there is no chance of early hearing of the appeal as stated by the land council. So on. So after going through the impugned judgment and hearing the land council for the state, in absence of any chance of early hearing, I am inclined to release the petitioner on bail. Bail allowed. Yes. Obliged.
Item 40.
Mr.
Item 41.
41 Ramakant Sahu, Ramakant Pradhan. Yes.
Although the power has been filed, but yet no document has been supplied to me. He has requested from the jail.
No, the request has been made to engage you.
My lord.
Have you filed your Bhinama?
Yes. But no document has been supplied to me. There.
It's a regular appeal. So whether Mr. Sahu has not handed over you the documents? No. ভিনামা ফাইল ହେଇଛି ଦେଖିଲେ ରମାକାନ୍ତ ପ୍ରଧାନଙ୍କର ଭିନାମା ଫାଇଲ ହେଇଛି ପ୍ରିଜନର୍ସ ପିଟିସନ ରିସିଭ ହେଇଛି ଭିନାମା ତାଙ୍କୁ ଏନଗେଜ କରିବା ପାଇଁ ଭିନାମା କଥା କିଛି ଲେଖା ହେଇନି କେବେ ଫାଇଲ କଲେ ରମାକାନ୍ତ ସାହୁଙ୍କ ଜାଗାରେ ରମାକାନ୍ତ ପ୍ରଧାନକୁ when you filed
adjournment this matter I will
ଲେଖନ୍ତୁ period the prisoner's petition received for engagement of advocate Ramakant Pradhan in place of Ramakant Sahu at flag D. Mr. Pradhan is present in court and submits that he will file the Vinama and the matter may be taken up on some other day. Put up this matter. 8 तारीख दरकार ना put up this matter on 8th of April 2024. Vinama be filed in the meantime. Yes, next.
Item 42.
May I please, your lordship? Appellant has been
Counsel for the state in course of the day. In course of the day. Put up this matter on 8th April 2024. Oh, yes.
Item 44.
Your lordship.
The appellant, yes, Mr. Das.
My lords, the appellant has been convicted, my lords, under section 304 part 1 and has been sentenced to undergo.
Have you supplied deposition copy?
Yes, I'll just supply, but he has I'm supplying.
Not sir.
Not so.
I'm just giving, my lords.
All right. Learned counsel for the appellant supplied the deposition copies of the witnesses examined in the trial court to the learned counsel for the state in court today to seek some time to go through the same. Put up this matter on 8th April 2024.
Great.
Item 45.
Wait, please, my lord. My lord, the petitioner appellant here is
Item 48.
My lord, in this matter, Honorable Supreme Court has been pleased to release me on bail, regular bail, considering my long incarceration. I am in JC from last more than 8 years.
No. You have been already granted bail by the Honorable Supreme Court.
Yes, just now, Lords. 4 to 5 days ago, Lords.
So this application then has no meaning.
Yes, Lordship.
IA number so and so, there is an application for bail. Mr. Sam Manol and counsel for the appellant has produced the bail order of the petitioner granted by the Honorable Supreme Court dated 22/3/2024, which is taken on record. In view of such order, this IA stands disposed of. This is taken on record.
I am obliged, Lords.
Item 49. Obliged. Item 50.
Free copy of the order given.
My lord, in this matter, on behalf of Ms. Soma Patnaik, seek the kind permission of my lords that I may be allowed to appear in this matter, Lordship.
Item number 50.
Yes, Lordship. On the behalf of Ms. Soma Patnaik.
Yes, Patnaik.
Yes.
Yes.
My lord, this is the criminal appeal of this year, last year, 23. The appellant has already suffered the judicial custody for 4 years and 3 months, approximately, Lordship. And he was on interim bail by the order of this Honorable Court by 14th 11/23, which has been further
14/11
23, Lordship, which was further extended by which has been
that was for a period of 2 months.
Yes, Lordship, and it was to expire on the 1st of the Feb. But in the meantime, on January last, 29/1, Honorable Supreme Court was pleased to extend that period, and by the final order of the March 11, 6 weeks time has further been allowed.
Okay,
And
so
it
now
has been
you are-
directed to.
You are continuing on that bail.
Yes, Lordship, by the order of this Honorable Court and further by the Honorable Supreme Court.
Okay, now when that period will lapse?
Lordship, it will last as per the order on the next April 16, approximately 6 weeks.
April 16th.
Yes, Lordship, 6 week. If we add 6 weeks from the March
So
11.
any kind of misutilization of liberty during interim bail.
That instruction I have not obtained, my lord. Last date, my lord directed to for hearing of the main IA, my lord. As per the direction of Honorable Apex Court, today the date is fixed for hearing of the main bail application.
Lordship, in this matter, one point is very important that I was not apprehended at the spot.
612 of 23.
Yes.
612 times Bharpale.
My lord, in this matter, one point is very much important in my favor, that I was not apprehended at the spot. I was arrested 6 days later of the alleged search and seizure, and there is no material on record whatsoever nature, except the confessional statement of one co-accused. So the whole order vitiates as per the bar of
This is
Honorable
filed by for appellant number 3 only.
Only
Yes,
appellant number
Lordship.
3.
Appellant number 3. He was apprehended after 9 days of the alleged search and seizure.
Just a minute. Appellant number 3, his name is
Brijmohan
Brijmohan
Gupta.
Gupta. And there is no material, even the CDR is not there, Lordship, to make any case that I was in touch with those accused persons.
So
who
two persons were apprehended
at the spot, Lordship.
One is Mahendra Kumar
And one
the
is
other is Muhammad
Muhammad
Azaz
Azaz Ahmad. They were apprehended on 19th of May. And I was arrested on 27 May, 8 to 9 days later. And except the statement of one co-accused, Lordship, there is no material against me of whatsoever
What
nature.
was seized from your possession? when you
Nothing.
were arrested?
Nothing has been seized from me. And I have already suffered more than 4 years, Lordship. So as per the Tufan Singh judgment and one recent judgment, Lordship, if my Lord permits me to, I will...
Anything?
My lord is there. I am placing my lord. Apart from the co-accused confession, banking transaction is there. The present petitioner transferred some 5,000 rupees to one of the co-accused. That apart, my lord, the present petitioner has 2 criminal antecedents. One is Ointhapalli PS case number 105 of 2017, and in that case 141 kg 717 gram of ganja was seized. Another Guntur, Gunaur PS case Sonipat, Haryana. In that case, the petitioner is also involved. NBW was also issued against.
That was a case under
NDPS.
So file comprehensive affidavit relating to the status of those 2 cases.
My lord,
Take the numbers.
Yes, I am
take the
supplying a
numbers.
copy.
Yes, please.
All right.
In one case,
Give it by one of an affidavit.
Lordship, may I submit one thing? In one case, there is no direct seizure
We
against
do not know
29.
what has happened. Give the comprehensive affidavit.
Yes,
Mr.
Lord.
Sham Manohar, Learned Counsel, files the appearance memo which is taken on record. During course of hearing of the bail application, that is IN number 612 of 2020. Yeah? Learned Counsel for the petitioner submits that though the petitioner was granted interim bail for a period of 2 months as per order dated
14 November
11 2023 in IN number 1815 of 2023, but the said period was extended from time to time by the Honorable Supreme Court, and now as per the
11th March order.
Order passed by the Honorable Supreme Court on 11th March 2024 in criminal appeal number 1527 of 2024, that is arises out of SLP criminal number 1178 of 2024. The petitioner is supposed to surrender on in the
16th April.
16th April 2024. The Honorable Supreme Court has, while passing the order of extension, has asked this court to dispose of the interim application. That was the order.
No, dispose of the main bail application.
Dispose of
the main
that
I.
application
This
was
is the main
disposed of.
application.
Yes, Lordship. This is the main IA for
Where
the
is that
bail.
order?
That order was last date
11th March order ta
supply करथिले last date रे.
Wait, 11th at flag. Okay. In the to consider and hear the bail application expeditiously, you know. During the course of the Learned Counsel, this is Mr. Naik.
My lord.
This is a matter of you are appearing for whom?
NCB, my lord.
Mr. Partho Sarathi Naik. Lennon, is it what
Senior Panel Council, Union
Senior
of India.
Panel Council,
Union of India.
Union of India appearing submitted that there are two criminal antecedents against the petitioner, and both are related to the
NDPS.
offense under NDPS Act. He has supplied the names of those two cases to the
Point
bank.
happily PS case number.
Give it. Just two cases you have said. He has furnished the name to Mr. Sam Manohar in court today, who seeks some time to obtain instruction about the status of those cases and file a comprehensive affidavit to that effect. So put up this matter in the what is that date you said?
16th April.
16th April. So
Surrender date.
Let it on 15th April 2024.
My lord, some earlier date can be. So if in
you are
case my bail is
supposed to file
dismissed,
that comprehensive affidavit. If
I will
you
file in the meantime,
All
lord.
right, then 8th April, on the 8th April, and the name of Mr. Sam Manohar be reflected in the cause list henceforth. Yes.
I am so obliged, lordship. One copy, please, sir. Thanks.
Item 51.
Objection.
Item 53.
Yes,
maximum sentence would be 10 years under section 3 of Explosive Substance Act with fine rupees 3,000. The appellant is in custody since 10 to 2015 to 22/3/2016. Then he released on bail. Again, he was in custody since 5/3/2023. More than 2 years, my lord. The age of the appellant is more than 61 years.
wait. The order that was passed on last time, that you threw a bomb on the villagers and number of persons had sustained injuries, and then the State Council took time to obtain instruction about the criminal antecedent, if any, against you from the IAC Buguda Police Station.
Yes,
my
sir.
lord. So
There's
anything?
two criminal antecedent.
Huh?
Two criminal antecedent. One is 302 is there.
Oh,
He was released on bail. 30.
file comprehensive affidavit.
My lord.
Note down the numbers. All right. The Learned Counsel for the state has produced written instruction received from IAC Buguda Police Station dated 23/3/2024 to the effect that the petitioner has got two criminal antecedents. The written instruction is taken on record. Learned Counsel for the petitioner seeks some time to obtain instruction about the status of those two cases and file a comprehensive affidavit. Put up this some other
1 week time.
1 week time. So 15th April 2020. It have taken on record.
Obliged.
Item 54.
May I please, Lordship? My lord, last occasion, my lord directed to me as well as my friend.
Obliged, my lord.
This only IN number 1984 tas you, right? And you take it 100.
Obliged, my lord.
Yes.
Item 59.
Mr. Mahanti.
Yes. Yes. Last time I called for the antecedent and all.
Yes, call for the
Antecedent.
submitted appellant was on bail during trial. He has never misutilized the liberty. Yes, anything CA? So, what is the conviction and what is the sentence imposed?
RI, that is one 326 and 307. One is 6 years and 8 years, but the allegation consecutively.
Oh, I see. What you have done?
That is the 307, the stabbing at the Bailey Miller, and another is the same thing is repeated. 326 is a stabbing. It is only
How many person received injury?
only one.
One person.
One.
No. If one, then why 326 again?
That is
307.
only one. Accused is also one.
Yes, Mrs. Sahu.
My lord. Again, the present petitioner, my lord, is stab injury, my lord, for which intestine came out, my lord, as per the.
No, it's all right, but why once you are convicting him under 307,
My lord.
why are you even convicting him under 326 and imposing consecutive sentence? The injured is same. It occurred in the same during the same transaction,
My lord.
and same blow has been given by knife. So then how it is maintainable? How this conviction, the two separate conviction for the same offense, 307, 326, and that two consecutive sentence. So if it is 307 sentence is gonna, then the sentence imposed is 8 years, right?
My lord.
And you are since when you are in custody or
I'm in custody.
from the when you are taken into custody on
to 28.
and you are released on bail. During trial you are on bail as it appears from
Yes,
the
I was on bail.
then after conviction you have been taken into custody
Since 28 6 to.
All right, heard the learned counsel for the petition, learned counsel for the state. The learned counsel for the state has produced the report from the IAC Saranpur police station. It's to the effect that there is no allegation against the petitioner about the criminal antecedent, and the report is taken on record. The learned counsel for the petitioner submit that the petitioner was on bail during trial and he has never misutilized the liberty. He further submits that the learned trial court was not justified in convicting the petitioner both for the offense under section 307, so also for the offense under section 326, and awarding two separate sentence and directing for consecutive sentences to run consecutively, because the injured is the same, the assault is the same, the occurrence took place during the same transaction. It is further submitted that there is no chance of early hearing of the appeal in the near future, and balance of convenience is in his favor, and therefore the bail application may be favorably considered. Learned counsel for the state opposed the prayer for bail. After going through the impugned judgment and we that injured,
The
evidence of the
PW7.
injured, PW7.
Shamsundar Patra, my lord.
Shamsundar Patra, PW7, and the doctor is PW?
Doctor is
14. 1 4.
PW14. and absence of any chance of early hearing, I am inclined to release the petitioner on bail, stay realization of fine, shall not indulge in any criminal activities. Violation of any terms and conditions shall entail cancellation of bail allowed. Yes.
Item 60.
Yes, Mr. Animesh Singh. None appears urgent.
Item 61.
Yes, Mr. Das.
May I please, Your Last occasion, Your Lordship call for a status report and a criminal.
Second April 20.
Fine.
Yeah.
Item 62.
In the first item, Lordship, last occasion after hearing the bail application, Lordship call for the CA of the appellant, my lord.
No CA, okay. Offense no.
Offense, my lord, 376D, 20 years, my lord. And my lord, since the medical report and the Siemens report will after
You are in custody or
custody, my lord, 19/6/20, my lord. Because, my lord, Lordship,
is 5 lakhs.
Cannot be compensated. His life has been spoiled. Yes, next.
Pardon?
65.
Pardon, madam?
It's rejected. Fine has stayed. Yes, next 65.
May I please, Lord?
Yeah.
My lord, in last occasion, status report from the learned court below.
No, it's a stay of realization of fine.
My lord.
IA number. So what is the conviction and what is the sentence?
My lord's conviction is 10 years, fine 1 lakh rupees.
So you are file an application for stay of realization of fine.
My lord.
286 fine allowed, stay fine. Yes, next. IA disposed of. Next.
Item 66.
66.
The die.
Mr.
May I please, Your Lordship?
Yeah.
A case under section 395 and was convicted for 10 years. There are two applications, my lord. May I pray my application may be adjourned for some time.
Okay, who is appearing for the second one?
My lord, I am for the second one.
What do you want?
Kindly allow 2 weeks time. My senior will appear in this case.
The CRL number so and so SS Roy 6 for an adjournment. Out of this matter, we commencing from 15th along with CRL number so and so. Yes, next.
In the meantime, criminal antecedent may be called for, my lords.
See, why yes,
Okay.
Already received, my lord. We can
already
receive.
received. Land Counsel for the state submits that he has received the instruction about the criminal antecedent. If you keep it with on that day, you will file.
Nice.
Yes, next.
Item 67.
Mr. Mitro, Devasis Mitro. So, non-obvious adjourn.
Item 68.
Yes, Mr. Mitro.
My lord, we have applied for the deposition copy, but not yet received. Kindly keep it to week commencing 22nd.
Land Counsel for the appellant 6 for an adjournment. 22nd you want?
22nd, week commencing.
22/4/2024. Yes.
Oh, please.
Item 69.
69, my lord. Conviction for 10 years, my lord. Out of which he remained 5 years, 8 months. Last occasion directed for production of custody certificate might have obtained.
What is the maximum sentence imposed?
20 years. Petitioner and victim having love
20
relation.
years for which offense?
No, my lord, 10 years.
I'm asking you that what is the sentence imposed? You are telling. So maximum sentence imposed 70, Mr. Smriti Ranjan Rao.
May I please? Last occasion, 376 AB is there, my lord. Notice is
Yes, 376 AB by notice ଯାଇଥିଲା କଣ
Extra
ହେଲା?
copy not, sir.
There was a direction to serve the copy, extra copy
Till yet extra copy
on
not, sir.
6/3/24. Why have you not served the
yes,
copy?
my lord. Extra copy already.
You have not sent it because you did not receive that extra copy. Mrs. Sahu, you did not receive that copy.
My lord. Oh,
So serve in an extra copy. What is
Extra,
that?
already so.
Serve another copy,
Yes,
Xerox.
ma'am. Also,
Learned counsel for the state submitted that in spite of the order dated 6/3/24, he has not received the extra copy of the appeal memo from the learned counsel for the appellant. Learned counsel appellant submit that he will supply the same by tomorrow.
today, ma'am.
Today, during course of the day. Let the learned counsel for the state after receiving the same comply the order dated 6/3/2024 and produce the confirmation letter regarding service of notice on the informant. Have you supplied the deposition copy?
Yes, ma'am.
Yes, Mrs. Saw. Learned counsel for the state, however, submitted that she has received the deposition copy of the witnesses examined in the trial. All right.
Item 71.
May I please receive?
Portable item
Item
number
67.
67. Arjun Koti. Yes, item 72.
May I please, Your Lordship? This is an appeal against acquittal. There is a delay of 72 days. And this is because the appellant was not aware of the fact that he could file an appeal, and due to financial crisis, he could not obtain the
Notice has
certificate.
been issued. Notice on this condonation, delay condonation matter has not been issued. Alright, IN number so and so is an application for condonation of delay. Stamp reporter has pointed out that there is delay of 72 days in filing this CRLA. Issue notice on the question of limitation, extra copy to be served on the State Council, requisites for issuance of notice on respondent number 2, speed post with proof of delivery, shall be filed within a week. Put up this matter after the notice on the respondent number 2 is made sufficient.
Okay.
Yes.
Item 73.
Please. Appeal against conviction by
Item 74.
74, Mr. Pradhan.
Yes, item 74.
My lord, in the meantime, the contracting counsel of the appellant is in government panel, my lord. 2 weeks time may be granted to file fresh Okalata.
What is the CRLA for?
For acquittal against
Acquittal.
my lord.
All right. The mention is made on behalf of Mr. Ashish Pradhan that the London Council is already in government panel and some other council steps are being taken to engage some other council for the appellant. Put up this matter in the week commencing 22nd April 22nd April 2024. If any London Council enters appearance for the appellant by filing Bhinama, the Bhinama be placed on record and his name be reflected in the cause list in place of Shivani Shankar Pradhan. Okay.
A copy not served in this case, ma'am.
Copy it, acha. Let a copy of the appeal memo be served on the Land and Council for the state. Okay. And Mr. Land Council for the respondent number 2. Upon respondent
2 to 5.
Acha, respondent number 2 to 5 is present.
Of limits.